Hello everyone, good day. I'm Alcalico Permares and today I'm going to share with you a quick guide to help lawyers and law students develop practical skills in legal interviewing. So to begin with, let's start with the interview aims. So imagine a client is arriving at your office in 10 minutes time. So what should your main objectives in interviewing them? So, a legal interview has three key aims. First is to establish an effective relationship with the client. Second is identifying the nature of the client's problem. And third, obtaining enough information from the client. So, next is the interview approach. So, an interview should have a logical sequence and structure without being too rigid. So there should be flexibility to allow the client to be treated as an individual with a unique set of issues rather than just a legal problem. So remember that an effective client interviewing technique will, will create a positive atmosphere between you and the client. So a successful interviews require the right atmosphere and as well as empathy. So what do we mean by atmosphere? It is An interview is not the same as a conversation. It has a specific purpose. So, an initial interview, this purpose is to identify the nature of the client's problems. A client will outline the nature of his or her problem, and the effective interviewer will probe for the salient information. So, remember that ultimately it is the client who gives instructions. In a legal context, a lawyer should be able to give options. So the next approach is the need for empathy. So remember, empathy is difficult to define, but essentially involves the interviewer attempting to understand the client's experience as well as the implications for them. So empathy is developed by effective interviewing skills. So remember that you will interview people from across the social spectrum and some of them who may have acted in a way you morally disagree with. So, as a lawyer, it is not for you to judge the client. You must have your verbal and body language reflect this non judgmental stance. So, for our top tip, take note that empathy is not sympathy. You do not need to feel sorry for the client, just understand their situation and their needs. So, next is the interview stages. We have here three key stages in a legal interview. So, the first stage is the listening, the second is questioning, and the third is advising. So, for the first stage is the listening. We are told that it is impossible to give good advice without having first listened to your client, which is true enough. So, listening is actually quite difficult to do so as it involves deep mental analysis of what you have heard. Effective listening, therefore, involves not only hearing what is being said, but noting the way in which things are said and the body language displayed while it is being said. So take note that for listening, silence can be an effective way of reflecting on what has been said. It involves taking notes when listening or asking questions or seeking clarification from the speaker. So these are both good ways of helping you gain more from listening. So the next stage is questioning. So often, clients will present information in a disorganized and incoherent manner. So questioning allows you to probe a little more about the issues raised by the client. So in reality, different clients have different ways of presenting information. So effective questioning obtains the information you need in order to provide the client with full and informed advice so that they can make the right decisions about the action they wish you to initiate on their behalf. So for our top tip, take note that paraphrasing or summarizing information is a useful way of highlighting areas where the information or evidence is required. So the third stage is advising. At this stage, the overall purpose of a legal interview is to enable your client to reach a decision as to which course of action they should wish to pursue. So by combining the result of listening and questioning, you should be able to identify what client's problem is what potential solutions are available. Again, remember that legal action is not the only necessary course of action in every case. So, we also need to take note that a client can only make the correct decisions if the advice is clear. So, make sure you avoid jargons. Second, you explain in layman's term. And third, summarize all the options again if necessary. So, client may worry about how much it will cost, including your fees. So, you should be able to discuss this with them. The other major worries for some clients is not knowing what is happening. So never mislead a client into thinking that everything is all right when it is not. Although you do not want to frighten an already distressed client, you must be honest in your appraisal of their situation. So next we have here top 10 tips for legal interviewing success. So, first, legal interviewing is not just about obtaining information, it helps establish an effective relationship with the client. Second, plan your interview, but leave enough flexibility and time for the client to be treated as individual with a unique set of issues. So, third, show empathy, as mentioned earlier, rather than sympathy with the client's situation. So, fourth, pay attention to your behavior when the client is speaking. Stay attentive and interested. So, fifth, listen to the nonverbal signals the client sends out as well as the words they say. So, another tip is that clarify what the client tells you by paraphrasing or questioning. You can also use silence to help you reflect on what has been said. And if necessary, take notes to help you remember key informations. So you can also offer potential solutions to the client, but let them decide which course of action to pursue. And lastly, listen to the client's worries. Be clear about fees and timescales. So next, we're going to show with you a sample demonstration applying the tips I've shared with you earlier for an effective legal interview.
Hi, attorney. Thank you so much for finding time to meet with me via Zoom. My apologies, attorney, that I cannot meet with you in person since my flight got delayed. I'm actually out of town to meet some business colleagues.
Mm. Yeah, good morning, Ms. Ninfa. So I am attorney Jane B, and I will be attending your case today. So, no worries about it. I understand your situation, and I really appreciate for giving me a heads up about our online meeting today. So Ms. Ninfa, I know what brings you here today.
Well, my friend sued me due to bouncing checks, attorney.
So there seems to be a problem with settling your money obligations, and you're now facing criminal charges and civil liability. Is that it?
Attorney, I haven't done anything wrong. I have no intention of doing anyone any wrong. I do not know why my friend decided to sue me.
Hmm. But do you know why he is filing charges against you? Like, were you given any reasons?
She said that I failed to meet my obligations. I remember receiving calls from her secretary reminding me to ensure that my checking account has enough funds. And she told me one day that I am a liar and a person without a word of honor, and that I did not do as I promised to
Hmm.
pay my obligations to her company.
Yeah, yeah, I understand that you feel that these accusations are unfounded. Like, why do you think he's been saying that you've been late with the payment?
I really don't know what to say. Attorney, this is so unfair. I just do not understand why I'm accused of being a person without a word of honor and being told that I'm a bad payer.
I understand. Like, to be honest, I would also feel unhappy if I were on your situation. And I really wanted to help you get out of this. I also need your cooperation in providing all the relevant information so that we can come up with the appropriate resolution. Okay?
What if, attorney, what if a person is late with payments? How does he defend himself?
Mm.
Will that person eventually go to jail? I might have overlooked some things, attorney, but or there were times that I deposited my money on the day itself when the checks become due, but I made sure my checks were funded. Perhaps this happened when I was on business trips.
Mm. You know what? Even if you are late with the payments, it doesn't mean that we can't find solution to keep away from the criminal charges. So I encourage you to disclose all details as much as you can so that we can get the end of it. Okay?
Attorney, I don't want to be imprisoned.
Yeah.
I just can't imagine myself in jail, attorney. I
Mm.
have children, and if I go to jail, who will take care of them, feed them, and who will send them to school?
You know, I really understand where you're coming from, and I will do my best to help you in this matter. So my main goal is to defend you of your rights and to prove that you did not commit of any of your friends and family accusations. But in the worst case scenario, you know, even if your friends, let's say, can get hold into a strong evidence against you, well, we can go to other options such as resorting to amicable settlement. Like, for example, you can just pay the obligation through cash or just issue another check.
Attorney, please help me. I never, im- I didn't imagine that my friend would do this to me. My friend knows that I am someone who will not run away and not pay up my obligations.
Yeah, I totally understand. Well, I understand that there may be times that, you know, we miss some of our payments. Like who would it? Like me, I am a bill payer myself, so I know where you're coming from, and I want you to know that I fully understand that you had your reason, which caused the missed payments. Now, let us look closer into the details about your payment arrangement and about the missed payments so that we can establish how much exactly you need to settle. So let's start with the how did you come up with the loan and payment arrangement? You know, can you tell me more about it, please?
My friend did me some favor by getting into a rent to own scheme for a car through her company. In return, I will pay her company an installment with interest, of course, by issuing 34 post-dated checks. I got some reminders of my obligations from time to time through her secretary, but I remember depositing money in my checking account. I always told them that no matter what, I will really pay. And then here comes my friend filing a case against me for violating BP 22. I really have no idea of the mess I am in now. I was told only 14 out of 34 checks were honored, and that there were about 11 that were dishonored. My friend's lawyer also told me that the last few checks that I issued had insufficient funds, or where either my checking account was closed, and that I was given like 5 days to settle my obligations. But I don't ever remember receiving any notice of dishonor of any of my checks, attorney. And if ever there were, I am very much willing to make up for it.
All right, got it. So just a quick recap. So your friend is alleging that 14, 14 out of 34 checks were honored. However, the other 11 checks, when deposited, were dishonored for a reason drawn against insufficient funds or accounts closed. And you were given 5 days to settle your obligations. Okay, so just to reiterate, you deny the fact about issuing the bouncing checks. Is this correct?
Attorney, one thing I can assure my friend or anyone for that matter, I really had no intention of running away from my obligations.
So I understand the info, but let me ask you again. Do you remember like, receiving any demand letter or any notice of dishonor?
Um, Again, attorney, I have told you before, I got calls from her secretary reminding me to keep sufficient funds in my checking account. that will be enough to cover my obligations, I always reply that I will pay.
Okay. Like, so you mean there was no demand letter sent from his lawyer or directly from your friend that the checks you issued were dishonored?
No single soul told me about it, attorney. I did not see or receive any demand letter prior to knowing that my former friend already sued me.
Okay. So again, let me ask you again that no one notified you that you did not have enough funds or credit at the time of the issuance of the check. Is that correct?
I do not have any knowledge about it, attorney. I cannot recall getting any notice of that sort.
All right. So, by the way, when did you learn or when did you first learn that the checks were dishonored?
I think I only learned it, or I was only informed that my checks were dishonored when my friend filed a case against me in court for having violated BP 22.
Okay, all right. So great to know all of these things, and I really appreciate your honesty. So we have now established that you do not have any knowledge about the dishonored checks, and this is necessary in proving them. So in summary, so we have established that there were 11 dishonored checks, but you were not given any demand or notice about it. So as they have failed to notify you about it, we have now a strong ground to overthrow the BP-22 case filed against you. All right, so here's what I can do for you. So we will going to file an answer against the complaint. And also we can resort to other options, such as settling this matter extrajudicially like out of court. You can pay the remaining obligation, but first we need to set a meeting with your friend and his counsel to discuss about this. So we also need to secure other evidence that we're not that you were not told about the dishonored checks. Like you can secure an affidavit from the secretary or from the bank or any other witness in case, just in case you will pursue the case. And you need to bring this and any other documents you have that will support a claim when we meet on our next meeting. So are you amenable with these options?
Yes, attorney.
All right, so I'm going to speak to my senior associate lawyer to make sure that I haven't missed anything. So I guess it would be all for today, Ms. Nympha. And before I let you go, I hope I have answered all your queries today.
Yeah, thank you so much, attorney.
Thank you so much. Bye for now.
Good afternoon, Ma'am Josie. Thank you for taking this Zoom call. I do sincerely apologize for not being able to come to your office physically as scheduled, but my secretary said that you wanted to consult on something. So, how may I be of assistance, ma'am?
Yeah, good afternoon, Attorney Kuyos. That's no problem. I would just like to seek your legal assistance or mm, yeah, about my concern and my predicament.
Okay. Sure. May I know in what way I can assist you?
Yeah, somebody paid me with post-dated checks without sufficient funds.
Okay, ma'am. Can I get more details, please, as to why you coming to the conclusion that those post-dated checks are without sufficient funds?
My mother, she has a friend, and then this friend issued 34 post-dated checks. 24 of those were good. We've already encashed them. However, when we presented the later checks, because di ba she issued 24, so
Mhm.
34, sorry. So when we presented the 25th check to the bank as payment for the loan that was due, it was returned to me, and then it was dishonored.
Okay, so may I know why she issued those 34 post-dated checks, and what did you do after you received a notice of dishonor from the bank?
Um, this friend of my mother, she bought a car, and then since she has no money for the down payment, my mother paid for the down payment on her behalf kasi they've been friends since before I was born. So
Mm-hmm.
in return, she will be paying my mother the purchase cost with no interest in 24 months, 34 months rather. So that's why there are 34 checks. Okay. So again, when we deposited the 25th check on the due date, it was returned to me with a notice of dishonor. So we tried informing her via text, via chat, and then I think one of our personnel even went to their house, and then to inform her that the check nga was dishonored. So the
Mm-hmm.
26th until the 34th checks were also returned. So yun, we repeatedly informed her of the dishonored checks and reminded her of her outstanding obligations with us. So
Mm-hmm.
um, she only responded by requesting for photocopies of the dishonored checks, and she gave the assurance that she will replace them as soon as possible, and then that she will settle the obligations um, in a one-time payment. And then after that, she acknowledged naman the receipt of the requested photocopy of the dishonored checks.
Okay, so based on the facts that you've narrated, what would you like to do next?
I want her to pay us attorney.
Okay, so you want us to file a case to extract payment from her? Am I correct?
I wouldn't really want to go to court just for this, because she is my mother's friend. But
Mm-hmm.
we did send her demand letter, and then she did promise to make payment, but it did not materialize.
Okay, so how was the notice of dishonor sent to her?
It was sent to her via her email.
Okay, and do we have any proof that the email was acknowledged?
I'm pretty sure the company secretary used the company's email.
Okay, so let me summarize the facts for you and kindly inform me if I got it all correctly, ma'am. So
Okay,
your
sure.
mother, yes, please, your mother paid the down payment of a car on behalf of her friend,
Mm-hmm.
and in return, she was under the obligation to pay the entire cost in 34 months. So she issued 34 post-dated checks. But from the 25th to the 24th check, all were dishonored. Am I correct?
To the 34th. 25th
O-
to the 34th.
Okay. So, are you interested in filing a case to force her in paying the debt?
She shouldn't be forced actually, right? Because it is her
Mhm.
obligation. But if it has to come to that in order for me to get the payment, then sure, okay.
Okay. Yeah, I do understand your point. So, but we can still continue negotiating with your mother's friend for possible out of court settlement while the case is still pending. So I guess that will be all for me. I don't have any further questions, but I will just be sending you the list of documents that I'll be needing for the preparation of filing the case. Would that be fine?
Yeah. What are we today? We're Wednesday, right? So
Yes.
I'll maybe just send my mother's secretary to your office, and then maybe she can text you when she's already there. Would that be fine?
Yes, certainly, ma'am. That will be fine.
Okay.
So just make sure that the envelope is sealed and it has been addressed to our office. And do text me also once it has been sent to my office.
Okay, sure, got it. Thank you, attorney.
Thank you also. Bye bye. Have a nice day.
Moving on would be BP 22 or the Bouncing Checks Law. Batas Pambansa Bilang 22 is the act penalizing the making or drawing and issuance of a check without sufficient funds or credit and for other purposes, or also known as BP 22. What is BP 22? BP 22 is simply the issuance of a bad or bouncing check. Take note that under Section 20, Article 3 of the 1987 Constitution provides that no person shall be present for debt. BP 22 is not violative of that provision as it punishes the act of the issuance of a bad or worthless check or failing to keep sufficient funds for payment of the check for 90 days from the date of such check, and not the non payment of obligation or failure to pay a debt. BP 22 is a crime malum prohibitum, meaning it is punished not because it is inherently immoral, but because the law makes such act criminal. As such, the law does not look into the intent of the offender, and as a consequence thereof, good faith is not a defense. BP 22 may be violated in two ways. The first manner is by making or drawing and issuing any check to apply on account or for value, despite knowing at the time of the issuance that he does not have sufficient funds in or credit with the drawee bank for payment of such check in full upon its presentment, and the check was subsequently dishonored by drawee bank for insufficiency of funds or credit, or would have been dishonored for the same reason had not the doer, without any valid reason, ordered the bank to stop payment. The elements of the first manner of violating BB 22 are as follows. First, a person makes or draws and issues any check. Second, the check is made or drawn and issued to apply on account or for value, either full or partial payment for an amount which is owed, or purchase of a merchandise or service on credit. Such check was subsequently dishonored by the drawee bank, even if the check is given or was given in payment of a pre-existing debt. If, however, the check was issued simultaneously with the creation of an obligation, or the check is the reason for the incurring or creating the obligation, then the issuer may be liable not only for BP 22 but also for violation of the provisions on estafa, which is a different crime. Third, the issuer who draws or issues the check knows at the time of the issuance that he does not have sufficient funds in or credit with the drawee bank for the payment of the check in full upon its presentment to the drawee bank. The check was subsequently dishonored by the drawee bank for insufficiency of funds or credit, or would have been dishonored for the same reason had not the issuer without any valid reason ordered the bank to stop payment. The second manner how BP 22 is violated is committed when any person who has sufficient funds in or credit with the drawee bank at that time he makes or draws and issues a check, but fails to keep sufficient funds or maintain a credit to cover the full amount of the check if the check is presented within a period of 90 days from the date appearing on the check, for which reason it is dishonored by the drawee bank. The elements of the second manner are as follows. First, the issuer has sufficient funds in or credit with the drawee bank at the time he makes or draws the check. Second, he fails to keep sufficient funds or to maintain credit to cover the full amount of the check if the check is presented within a period of 90 days from the date appearing therein. And lastly, the check was dishonored by the drawee bank. Now we move on to the problem areas in BP 22, which are as follows. First is the inability to serve or non receipt of the notice of dishonor by the check issuer. Second, the courts are used as collecting agencies. Third, there is no valid consideration or the obligation has not arisen. The first one is the inability to serve or the non receipt of the notice of dishonor by the check issuer. The notice of dishonor must be given to the doer in order for the presumption of knowledge of insufficiency of funds to arise. The law requires that the notice of dishonor of the check must be sent to the doer. So after the drawee bank stamps drawn against insufficient funds or account closed or any other similar terms, the payee or the holder of the check must now send a written notice of dishonor or demand for payment of the value of the check. The lack of the written notice of dishonor is fatal, which could lead to the dismissal of the case. To hold a person liable under BP 22, it is not enough to establish that a check issued was subsequently dishonored. There must be proof of receipt of a notice of dishonor because it gives the maker, drawer, or issuer an opportunity to satisfy the amount indicated in the check and prevent prosecution. It must be shown further that the person who issued the check knew at the time of the issue that he does not have sufficient funds in or credit with the drawing bank. In other words, if there is no proof as to when such a notice was received by the drawer, then the presumption or prima facie evidence cannot arise, since there would simply be no way of reckoning the crucial 5-day period. The 5-day period provided is a time frame wherein the issuer can pay the obligation in cash or provide any other alternative form of payment. The service of the notice of dishonor is not always made through personal service, but alternatively by registered mail. However, the Supreme Court has consistently ruled that the receipt for registered letters, including return receipts, do not themselves prove receipt. They must be properly authenticated to serve as proof of receipt of the letters claimed to be the notice of dishonor. Obviously, the presentation of the registry card with an unauthenticated signature does not meet the required proof beyond reasonable doubt that the accused received the notice of dishonor. It is not enough for the prosecution to prove that a notice of dishonor was sent to the accused. The prosecution must prove the actual receipt of such notice, and problem arise when the issuer refuses to receive the notice of dishonor or had relocated to another location. Second would be using the court as collecting agency. Before the year 2000, the practice of drawing and issuing bad checks was somehow deterred by the threat of imprisonment of the erring maker, drawer, or issuer under BB 22. The certainty of arrest after determination of probable cause, the rigors of trial, and possibility of conviction were enough reasons to pay or honor the value of the checks. Further exploiting the fear, lenders required borrowers to issue post-dated checks as security for debt obligations. While this may appear to be an advantage for them, they were constrained to shoulder the cost of litigation. To some of them, this was an unnecessary expense, which will have an impact on the final amount of their monetary recovery. To minimize the cost of litigation, lenders and financial lending institutions learned to prepare their own demand letters and affidavit complaints to be filed with the office of the prosecutor. They also learned that hiring private prosecutor was not necessary, since BP 22 cases were prosecuted in court by government prosecutors. The knowledge of the workings of the legal system emboldened these lenders to file countless BB 22 cases, which unfortunately resulted in the clogging of the court dockets. And lastly, there is no valid consideration or obligation has not arisen. It has been a common practice amongst lenders to ask debtors to issue post-dated checks to secure the payment of an obligation. There are instances wherein the obligation has not been due and demandable. However, the debtor would attempt to deposit the check despite knowing that the check would bounce as it is not been funded. As such, the depositing of the check was in bad faith. Or in another instance, the debtor would request to have the check be posted on another date as there are no funds in the account yet, but the lender would instead deposit the check to push the debtor to pay instead to exploit the debtor's fear of prosecution. In both instances, while BP 22 punishes the act of issuing an unfunded check, however, the creditor in both cases would cause the debtor unnecessary expenses, as corresponding fees may be charged by the bank for dishonored checks. Further, the fear of prosecution would cause alarm to the debtor and force him to engage the services of a lawyer. Issues those mentioned could be easily avoided, and expenses could not have been incurred if the parties themselves would choose to do so. That ends our presentation. Thank you for watching and have a wonderful day.